Anybody else joined us since we last recessed? Other than Mr. Uhalski, who I haven't seen so long, he's grown a mustache. Anybody else? Okay, all right. All right, folks. As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts one. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as courts 2. So the transcript will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators, Long
everybody
and Hamilton,
except for the defense,
the court, and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told to him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as court 6.
Because he wouldn't say who he got the information from.
At 7:41 p.m.
Unbelievable.
The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court's already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present.
That's illegal.
Second assertion he makes
That's
is that
illegal.
Mr. Copeland intended to plead the Fifth Amendment.
Okay, so just really quickly, a little bit more context. Remember, there was a secret meeting between this judge, Suge Knight Glanville. That's my nickname for him, by the way. Let me know if you like the nickname, replay viewers, live viewers. There was a secret ex parte meeting between the judge, prosecution, Fannie Willis's district office, and a key witness, Lil Woody, our boy. Huh? I don't know. She fired. That guy. I love Little Woody, actually. He's probably one of the most entertaining defense witnesses or witnesses ever in the history of witnesses. And he did not let the defense know about it. And then once Mr. Steele, who you see on the screen right now, defense counsel Steele, who's Young Thug's attorney, once he got word of it and wind of it, he approached and basically confronted the judge and said, "Judge, what's going on here? Like, what's happening here? How come I wasn't notified of this?" And instead of the judge actually saying, "Oh, you know what, it must have been some kind of mistake," or "You definitely had every right," because every single statute and law in Georgia, in Fulton County, everywhere, you have to let the defense know why wasn't the defense in the meeting? Why are you having an ex parte meeting? And was there coercion? And then number 2, why didn't you at least, okay, let's say you had an ex parte meeting. Why didn't you let us know, AKA the defense? Why didn't you let the defense know? And so this is it's bonkers. And then instead of doing the right thing, he arrests the attorney right now, Brian Steele, that you see on the screen. So just to get you all caught up. And now, after tons of pushback, this is what's happening.
Third assertion is that Mr. Copeland, as a party, was sworn And Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage, and it only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland.
Transcript will be made public, y'all. You know we're going to go live for that. Follow and subscribe.
I'll
It's free.
address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contended the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional.
Oh, here we go.
Indeed, some situations
He's
the trial
justifying
judge
it
may
now.
find an ex parte conference necessary. We cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983 where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about the threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They see United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142 and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, are disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court with the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6. And this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on the case law, that that this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Seals raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for for portions of the trial that involve questions of law and consists of essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees a criminal defendant the right to be present and see, hear all the proceedings which are had against him or trial before the court. It's Prickett versus the State, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
He's just trying to save face now. That's all he's trying to do. He was wrong. He knows he was wrong. Without this pushback, he would not have released the transcripts. And the transcripts haven't been released yet. We don't know when they're released. And we don't know.
Further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and or our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this along with the attachments will be included in the record. And Mr. Banks, where are you? Sir. As a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. As I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that, so we will not be holding that particular hearing. Okay? All right. And then then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge.
Whoa.
Pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time.
Whoa.
And we will just inform our jurors that they're content until this is. They're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time. Okay? All right.
Wow.
Ms. Novi, can I ask you a question before you start anything? Madam, didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case?
No.
I'm asking you at this point in time, could you state for the record how it is that you don't think you have a conflict? Because you did represent
Look who's
one of the
talking
co-accused
conflict.
in this case, correct?
I did.
Okay.
Talking about
Discharge. Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed that or come up and what happened in the ex parte proceeding. We're just representing Mrs. Bumpus, Attorney Bumpus, in what her position is with respect Is that on mute?
Yeah, you're good now. Yeah,
With respect to this court.
Oh, just like that.
So,
You're good.
completely different matter. And now we're dealing with a contempt hearing of Ms. Bumpus
Live
as opposed to
national
a
television.
criminal prosecution of Mr. Kitchens. Completely different. And in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict. I just wanted to bring that to your attention. So if you think that it should be addressed, then I'm
we could
giving
have
you the
done that in
opportunity to do
private.
so at this point in time.
You just don't-
Because you do have knowledge of this particular case, but all right.
Well, I think
What-
half
what
of
else?
America
I'm
has
sorry?
I said I think half of America has knowledge of this particular case at this
Well,
point.
but okay, but
Exactly.
but they're not before us at this point in time. So what else did you want to?
Well, and I'll speak for the court's purposes. I'll speak for myself and John Garland, who's also our co-counsel with Attorney Bumpus and who was my co-counsel in Mr. Kitchens' case.
All right.
So I'll speak for both of us in that
He'll
respect.
do anything he
since Mr.
can to
Garland's
take
not
the
able to be
spotlight
here.
off him.
All right.
A couple things
see, I'm
that I
not the
just
only
wanted to
one.
clarify for Your Honor. Is the court still intending to produce an order on what the court addressed orally on our recusal motion?
Yes, ma'am. I'm going to produce an order basically bundling all, since there are 3 motions to recuse, to one to
Go
be
to
spun
somebody
on
else.
the wheel so that we don't get 3 separate people hearing these particular matters. So I will do that effective today.
Okay.
So does that answer your question?
It does with respect to that. The other issue was I think the court was holding under advisement our motion to quash.
That makes this moot at this point in time.
Okay. So
Since I'm not going to have a hearing at this point or at any time in the future, you can re-raise it at that point in time if you so desire.
that's fine. So we'll just
But
leave it.
I'm telling you, at this point in time, I have no desire to resolve that. I don't need to at this point in time.
Okay. All right. Those are the questions that I had.
Okay,
Thank you.
all right. Madam, unless you have anything else, you all can be excused. Counsels, I'm going to go ahead and, like I said, work on this particular order. I actually memorialized the order in writing and the motion to recuse in terms of the sending it to another judge pursuant to 25.1 through 25.7. And we'll see in a little bit, depending upon how it's ruled upon, all right? All right.
Your Honor, do we have a timeline of when the motion to recuse may be heard?
Don't know. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Miss Alexander and her team spin that,
Wow, no
timeline. That's not within my information and purview.
Is this something that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is there anything that could be expedited so that those decisions can be made on the motion to recuse and we can move forward with the trial?
While I understand your concern, I think the rules of transfer and recusal are pretty clear that I'm not going to comment on anything that is pending at that point in time. So, hopefully it will get done fairly quickly in terms of somebody acting on it. Okay.
All right, thank you, Your Honor.
Okay. Anybody else?
Wow, no time.
Mr. Steele, you rose just a second ago. Did you want to say something, sir? No, I thought you were recessed. Okay. All right. Okay. Okay. Then we're in recess and we'll see you in a little bit. Okay. All right. We're in recess.
It's actually not a little bit. Okay. It's actually not a little bit because okay. So if you're just joining us, holy macadamia nut. So just a little recap, and then I want to talk about this. I mentioned earlier that I was going to connect this to Fani Willis. It has such a strong connection to the 2020 Trump case, election interference case with Trump, the immunity case, the Supreme Court, and all of this is kind of poetically interlinked, intrinsically interlinked. But just a quick recap here. So the RICO trial against rapper Young Thug and his YSL associates has been paused indefinitely as it enters its 100th day. Please tap that thumbs up and thank you. And by the way, super chats and new members, stick around to the end. I'm going to give you all a shout out live on screen. Stick around, more to come, okay? On its 100th day, presiding Judge Ural Suge Knight Glanville, sorry, I'm indulging, I apologize, ordered a halt to the proceedings on Monday. I just love that nickname. This decision comes after motions were filed seeking his recusal from the case, which now need to be reviewed by another judge before the trial can continue. So think about this. All the money, all the taxpayer dollars, the tens of thousands of cases that are backlogged because Cash Money G, our girl, you know her, I know her, you love her, I love her, decides to go after these high-profile cases, decides to get the spotlight, decides to go to cocktails and conversations, decides to go balling with Shaquille O'Neal and LeBron James and Michael Jordan and Denzel Washington, instead of doing her job. This is all in Fulton County, you guys. This case, the Trump case, Fulton County under the DA, Fannie Willis's district. Judge Glanville also stated there's no timeline. That's insane. So we have no idea how long this is going to take. We have no idea how long the recusal hearing is going to take. We have no idea what the outcome of that is, which means this trial, which has already taken over 100 days, this poor jury, all the taxpayer resources, now because of this hubris-infested egomaniac who doesn't understand the law, but he's sitting on the bench, Judge Earl Suge Knight Glanville, because one mistake, which he got caught red-handed committing and arrested Brian Steele live in court. We did a video on that. Holy mackerel. Now there's absolutely no timeline. You heard the prosecution. The prosecution said, can we get something? Can we get some kind of a timeline? When's this going to start? Can we get it expedited? I mean, what are we supposed to do? Just hold this jury forever? What are we supposed to do? This is a murder trial. Hello? Prosecutors expressed concern about the delay and requested an expedited process for the jurors' sake. However, Glanville maintained that, quote, the rules of transfer and recusal are pretty clear, end quote. This isn't the first time that Glanville has faced motions for his recusal. He already denied 3 previous motions. Last week, the Georgia Supreme Court decided not to pause the case, adding another layer of complexity to this insane proceeding. Okay. And then what we just saw, he addressed the controversial June 10th ex parte meeting between him and prosecutors. Defense attorneys, and I agree with them, I'd love to hear your thoughts, let me know, have labeled the meeting, quote, unlawful, end quote, leading to attorney Brian Steele, who you saw in court next to Young Thug, being held in contempt and sentenced to a 20-day jail term, which has since been reversed by the Supreme Court. Glanville has defended the private meeting like he just did right now, citing several laws to justify it, wrongly so, completely disparate and disconnected, conflating things that don't deserve to be conflated, and ruled, here's an important one, that the transcript of the meeting shall be released. OMG. I need some water. What I need is some water right now. Excuse me. Holy macadamia nut. My glasses are getting all fogged up. I mean, the drama for your mama just never stops in Fulton County. It just never stops. It is a ceaseless days of our lives, General Hospital, Law and Order, a horrific comedy of errors. And the sad thing is, the people of Fulton County, the constituents, the people who want to get their case heard but can't because they're backlogged, because all these people want to do is just chase the limelight, and all the taxpayers. The sad thing, the tragedy here is those are the people who bear the brunt, who bear the major suffering because of these inept, unqualified, egregious officers of the court. They don't deserve to be officers of a Chick-fil-A in Kenya, let alone presiding over major cases. I would love to hear your thoughts on this. This is just insane. We've been covering this case for a very, very long time. We were covering Cash Money G, her disqualification hearing. Now it's going to the appellate courts. Now, here's the connection. I said there was going to be a connection, okay? And all super chats, thank you so much. I said there was going to be a connection. And here's the connection. And I just touched upon this briefly. The connection is this. These two cases should have never been launched. The millions, not thousands, not hundreds, the millions of dollars that have been wasted here, chasing the limelight, chasing the spotlight through self-interest, nepotism, hubris, ego, megalomania, self-importance, self-indulging, self-absorbed individuals, aka Cash Money G. Fannie Willis and Judge Glanville, instead of doing the right thing. All he had to do, this case could probably be, who knows? I mean, it could be finished by now. All he had to do was be like, you know what? Because as an officer of the court, same thing with Fannie Willis, by the way, because I'm an officer of the court, because I care about the criminal justice system, because I care about doing the right thing, I'm going to recuse myself, not because I did anything wrong. He didn't even, you guys, this is the insanity. He didn't even have to admit that he did anything wrong. Because remember, not only are you supposed to have nowhere near any kind of impropriety, but as an officer of the court, as a district attorney, as somebody who's presiding over a very important case, you're not even supposed to have a hairbreadth's appearance of impropriety. And instead of doing the right thing and saying, I recuse myself, I didn't do anything wrong, but there seems to be a little haze, a little nebulous cloud of impropriety, which is more than enough to recuse yourself, more than enough to take yourself off the case. I'm going to go ahead and recuse myself. No. What does he do? How did you find out about this? I need to know how you found. You need to tell me right now. That was secret expert. He even said it. I mean, he even said it out loud in front of a national audience. There's no propriety with these individuals. How did they get into these positions? Well, I got a pretty good idea how they did. And I think you do too. And it's an acronym with 3 letters. Even if there is a molecule of an appearance of impropriety, you got caught red-handed. You arrested the counselor, defense attorney Brian Steele, in court live on TV. The Supreme Court shouldn't even be hearing this stuff. The Supreme Court overturned your ruling to hold him in contempt. And now the Supreme Court says, no, another judge needs to hear this. The Supreme Court of Fulton County, which hopefully there's some logic because they actually agreed to the Pitbull Sadow appeal. Oh, I love this. I love this. I love this comment from Cowboy Rob. You know, how did you find out? I did something illegal. Tell me or I'm putting you in jail. That seems to be the mentality of this. It's all interwoven, y'all. This is not, they're going to call me a conspiracy theorist. I am an intelligent, I'm not a teenager. I'm not a 25-year-old. I'm not even a 35-year-old. I'm not even a 45-year-old. Okay. I've been around the block. I've run businesses. I've worked in the public sector. I've taught business communications and Aristotle's principles of rhetoric at some of the finest top universities in the world. I'm not a newbie on this block. I know how this stuff works. I've worked with a lot of these people. I've worked with people like Cackling Kamala. I've worked with people like Dr. Jill Biden Flotus. I've worked with these people. I know what their souls permeate. They are rotten to the core. They have zero scruples, and they don't give a rat's ass about you, and they don't give a rat's ass about me. And this is how they operate. Protect their own at any cost. And once that becomes too close to home, they devour their own. Protect their own at all costs, sacrificing Americans' lives, sacrificing our border, sacrificing our economy, sacrificing our global respect, sacrificing the American really infrastructure of who we are as a country, our values, our principles at our core, sacrificing everything just for retaining power. Much like Cash Money G should have recused herself, got caught expending tax forfeiture funds, got caught lying under oath, got caught committing perjury, got caught on vacation hiring a special prosecutor who's not qualified at all, which has never been done in the Fulton County DA's office. I mean, is that an appearance of impropriety? No, that's a blatant, full-fledged tsunami of impropriety, and shame on you. This is the whole purpose, y'all, of my channel. This is the whole purpose. We need to snuff these lion-ass dogs out, these LADs. We need to snuff them out. We need to get our country back. Enough is enough. The greatest thing that ever happened to this country in the last couple of years, 10, 15, 20 years, is the fact that people like myself, who are not beholden to people like Pfizer and Chevron, can actually tell the truth. I do my own due diligence, my own quantitative and qualitative research. I've been doing it for decades. I know these people. And what are they going to tell you? I quote George Orwell. I quote George Orwell. This has everything to do with this tribe, this cult. They're not even, you can't even say, honestly, you can't even call these guys Democrats. I'm serious. I'm not even joking, you guys. This isn't the Democratic Party. This is a unrecognizable cult that is so extreme, so far radicalized to the left that you can't even describe them. It's demonic. I quote the great George Orwell from 1984, quote, "The party told you to reject the evidence of your eyes and ears. It was their final, most essential command." End quote. This is the most consequential year of our Lord since 1861 for this amazing republic called the United States of America. We, the people, hold all the keys. We, the people. That's what a democracy is. A democracy is the people control their land. They control the government. Remember, they work for us. They're public servants. The vegetable in chief, he's our employee. They work for us. They're public servants. This is the most consequential year of our Lord. And this is why I'm doing this. And you can see the connection. You can connect the dots. You can see self-interest. You can see megalomania and narcissism. You know, I got to hand it to what Trump said in the debate. You know, I mean, say what you want about him, and believe me, there's a lot of things that sometimes, even though I love him to death, and I think he's amazing, and I think he's got the right purpose, and he's definitely somebody. Come November 5, we should all galvanize around. But he said something that was, I thought, that the media didn't really cover, but he said something very poignant. He said, "I wouldn't be here if Biden wasn't doing a good job. I wouldn't be here if these radical, extreme, left-wing communists who are destroying such beautiful American cities like Chicago, Washington, Portland, San Francisco is a dystopia. Los Angeles is a cesspool. I live in California. Gavin Newsom's destroying our state, and he will be the next nominee. I promise you, he will be the next nominee. It is going to be Trump and Newsom in the next debate, which probably won't happen until September. And you know, your boy Nez is going live. Hello. So this is all interwoven. This is all interconnected. And when I say down there, tap the thumbs up and subscribe, this is not vanity. This has nothing to do with me. I could care less. The only reason I say this is because when you do something as easy and free and takes a nanosecond to tap that thumbs up, guess what happens? The algorithms of these platforms, they go, "Oh, wait a minute. People are liking the video. I know what we should do. Let's push this out to more people." Then we can spread our message. Then we can get our country back. That's why I'm doing this. That's why I say tap that thumbs up. That's why I say subscribe, because we need to come together. It's no longer the elitist woke mafia. The government's not going to help us. And the reason they're so afraid of Trump, the reason they're throwing sham trial, weaponizing every branch of government, doing everything in their power to stop him in this volcanic, polluted media campaign of lie after lie after lie they're spewing, is because he's going to go in there and fire everybody. He's going to get rid of the Department of Education. God bless him. He's going to get rid of 75 to 80% of the useless bureaucracy in our government that we're paying for. We're paying for their livelihood to sit there and do nothing. Nothing. They don't do anything. And he's got the people. He's got the populist vote. Who does Biden have? George Clooney? Robert De Niro? I'm supposed to listen to Robert De Niro, a guy who makes $20 million a movie? Of course he wants to defund the police. He's got private security. Of course he doesn't care about inflation. Money is no object to him. Of course he doesn't care about the border. He's got gates. He's got his own wall around his house. When's the last time you think Robert De Niro went to a grocery store? Shame on you, De Niro. Why don't you move? Why don't you move to a country that you actually support? You want to step up to me? Step up to me, De Niro. I dare you. I triple dare you. I will go face to face, toe to toe with you any day of the week. You mutt, you mook. You've ruined every great movie that I used to love growing up as a kid. I can't even show The Godfather to my son anymore because your ugly ass is in it. Your treasonous, traitorous ass is in it. Screw these celebrities. They can't relate to us. Jimmy Kimmel, they can't relate to us. Okay. I know. Once I get going, it's hard to stop me. I know. Okay. I want to do so that's what's happening. That's the connection. And, just kind of in short, just to kind of sum it all up here. I do have to go because I gotta go pick up my kids. In short, okay, this is what it's all about. And you can see the connection between Cash Money G and this case that's happening against Young Thug. So that's the connection, and I hope it makes sense. And I think Orwell's quote, because it's the same thing, like Glanville, Judge Suge Knight is essentially saying, don't believe your eyes and ears. No, I didn't do anything wrong, even though I had a secret meeting without telling anybody. Don't believe your eyes and ears. Biden's as sharp as a tack. Don't believe your eyes and ears. No, of course not. Mayorkas. Oh, don't believe your eyes and ears. The border's great. No, we've had an amazing. And by the way, the Border Patrol supports us when actually they went on Twitter X and posted, we don't support Biden. Don't believe your eyes and ears. The border's fine. Don't believe your eyes and ears. You can get gas. You can get groceries. Your rent is fine. Inflation is fine. Mortgage interests are fine. Don't believe your eyes and ears. Believe us. It's the same thing. It's all interconnected. We need to get our country back. Okay. Rant finished. I apologize. Thank you for indulging. But I think it was important. It was more than just indulging. But I love you guys. I'm so happy you're all here. You guys are absolutely amazing. And I really, really appreciate you guys. So let me give some shout outs. I want to give some shout outs. And then I have to get out of here. I love you guys so much. Loretta and make sure again, in the pinned comment is our free newsletter. That's your fail-safe way of never missing out. It's free. Just put your best email in there and boom, you're in. Thank you so much for the $10 super chat. You rock, Loretta. Thank you so much, Staten. When you find yourself in a hole, put the shovel down. You better believe it. Thank you, Kids Relevant, for the $20 super chat. You're amazing. No matter what, do not get weary in well-doing. I love the way you said that. Fantastic. Thank you so much, Sal Renzulli. What am I, a schlemiel? Hey, Sal, how about a little pasta fazool, huh? Sal's here. I love that name, Sal. Great to see you. I got a little Italian in me too, as you can tell. Sal, thank you. Says, great coverage throughout. I appreciate you, Sal. God bless you, sir. God bless you. Michael Williams, thank you so much for the $1.99 super chat. Love the content. No, you did not. This sit down, Hilton. Thank you. Thank you, Michael. Christina, thank you so much for the $10 super chat. You're right. All these cases are linked with the Trump case. Please explain how and why. Cop City, Israel, Hamas. How is this all connected? It is because just to kind of make it simple and short, the reason why, Christina, it's all connected is because leadership starts at the top. When you have a cancer in the leadership, it trickles down into every artery, every branch, every artery of our lives. And so that's why we need to galvanize. That's why we need to come together. That's why we need to really make a huge blast, a huge loud bang on November 5th. Thank you, Sal. You're amazing. Does this also mean that jury remains sequestered at this point in time? Yeah, it does. It's so sad. It's so sad. Christina, thank you so much. I live in Atlanta. There have been many other mysterious things going on. I can only imagine. I mean, this is only the stuff that's televised. Can you imagine the stuff that's not televised? That's behind the scenes? Holy mackerel. Shooting at a bus left. Oh, yeah, I remember that outside a courthouse. What's real? Exactly. I love the way you said that, Christina. You're right. Brooks Kelly, thank you so much for the $5 super chat. Is the dropping of the Chevron doctor and the nail in the coffin of the Reno regulations for a special counselor? I need to kind of research that a little bit more before I give an answer. I kind of have an answer, but I need to do a little bit more research on that. I don't want to give, I don't want to say the wrong thing. Thank you so much. That's a great question. I'm going to research that. Cowboy Rob, how did you find out I did something illegal? Tell me or I'm putting you in jail. That's your Democrats. Cowboy Rob, salute you. It's awesome to have you here. Fletcher Boy, thank you so much for the $9.99. Allegedly, D.A. Willis directed the judge and prosecutors. Exactly. 1 billion%. Fletcher Boy. Everybody give Fletcher Boy a huge round of applause. You're 100% right. I love the way you said that. Everything starts at the top. Joseph Ricard, it's great to see you. The judge deserves to be locked up for being a corrupt judge. He should have been recused from this case, wasting money. Let's get our country back. I love you, Joe. I'm so happy you're here. Bernie Cifoletti. Hey, Cifoletti, how about a little, spaghetti with clam sauce, eh? I can't wait for the Pitbull to be on your show. He is going to be on our show. He promised me. He obviously can't do any interviews while the case is ongoing, but I have the word of the Pitbull. Say down. You better believe it. Christina Weir, how is this connected? Yes, I think I answered that. Thank you so much, Christina. I hope you're still here. Damon Curry, thank you so much for the $5 super chat. I think Glanville acts like this because he was a military JAG officer. The judges are treated like God and work with the prosecution. Thoughts? Yeah, 100%. 100%. It's all connected. Absolutely. Bitrage, thank you so much. Wouldn't they have to refund all campaign donations if Newsom gets rotated in? Yes. Although the problem is all the donors are the ones who are trying to get Biden to leave. So they're happy to shift their donation to Newsom. Their only goal is to retain power. And the only threat to that is Trump. Period. I mean, there's also a lot of interesting research that I've been coming up with. Thank you, Grace. Thank you so much. Appreciate you. Love you, Grace. There's also a lot of interesting research that I've been coming up with that a lot of people have found and discovered and elucidated that perhaps the Ukraine war is just a big money laundering scheme. More to come on that. Make sure you stick tuned. I just want to say thank you guys so much. I mean, please, before you leave, tap that thumbs up. We need to get this to as many people as possible. And stay tuned because your boy Nez is going to cover everything. I will cover everything. Deborah, thank you. Deborah says, Nez, don't forget your kids. Okay. I love you, Deborah. Thank you so much. Thank you for the reminder. I love you guys. I love you guys so much. Thank you so much for being here. Bernie, you're the man. Cifoletti, how are you? This will have to do for now. Thank you, Bernie. You're the best. I love you guys so much. Please stay tuned. I ain't going nowhere. We're going to be covering this and a whole lot more. Check out my new video I just dropped today on the Supreme Court hearing. I broke down everything that you need to know. It's going to come up here on the end, as well as it's on my channel. Just go check that out. It was dropped today. A full breakdown, almost an 18-minute video breaking down everything you need to know about that Supreme Court ruling step by step. Check that out. As always, may God bless you and may God bless